Good morning, everyone. So, because of my busy schedule, I am giving this recording videos. तो इसमें factual करके थोड़ा पढ़ाएंगे, and then later on, whenever there's a need, we will do extra classes to discuss issues based on the relevance ना in the current scenario या current affairs के साथ जो relevance है उसके हिसाब से we will be doing important issues also जो हम लोग करता ही वैसे भी तो वो है तो हम लोग last time we started आपका right to freedom of religion राइट टू फ्रीडम ऑफ रिलीजन को हम लोग ने लास्ट टाइम वी स्टार्टेड तो उसमें वी वर लुकिंग एट आर्टिकल 25 तो हम लोग आर्टिकल 25 को देखा तो बेसिकली आर्टिकल 25 प्रोवाइड्स फ्रीडम ऑफ कॉन्साइंस प्रैक्टिस एंड प्रोपगेशन ऑफ रिलीजन तो ये सर द कार्डिनल्स या आपका कोर बोलेगा या बेडरॉक बोलेगा ऑफ सेकुलरिज्म दिस आर द बेडरॉक ऑफ सेकुलरिज्म ना जो आर्टिकल 25 तो बेसिकली फ्रीडम ऑफ कॉन्साइंस क्या होता है इनर फ्रीडम you can relate to any god na your relation to any god okay so you should have that inner freedom that is freedom of conscience and then profession means you can declare your religious belief ki I am a donji polo I am a Hindu I am a Muslim you can profess your religion that you can declare about your religious belief and then practice okay practice means you can uh, do perform ritual ceremonies etc which are needed for your religion which are essential for your religion okay so that right you have and then you have the right to propagate means transmission and dissemination of one's religious belief no? You have the right to transmit the knowledge the teachings of your religion to others okay but not no forceful conversion so basically here it is written it does not include the right to convert another person uh, to one's own religion. So it does not include conversion wala thing. Okay, no right to forcefully convert anyone. And then applicability. This article 25 is applicable to citizens as well as non-citizens. So citizens could be citizens and even non-citizens have this right. Okay? So right to freedom of religion. Na? So this freedom of conscience, freedom of profession, so yeah, even for citizens and then as well as non-citizens. Na? So yeah, but see, as I said, every right entails certain restrictions, yes, certain your exceptions. No? So like you might be having right to freedom of religion, but it will entail certain restrictions. Suppose you have the right to perform rituals, but you cannot perform some of the rituals which will infringe upon the morality of the society, a public order, which will help, which will have negative impact on the public morality. Okay, a public order. तो ऐसा वाला चीज को you cannot do ना. तो ये है ठीक है. So then Article 26. Article 26 is basically freedom to manage religious affairs. Okay, that is basically it deals with freedom to manage religious affairs. So this article basically entails what it entails right to establish and maintain institution of for religious and charitable purposes. Okay, and then right to manage its own affairs. Okay, in matters of religion, and then right to own and acquire movable and immovable property movable immovable property भी रख सकता है and then that to administer such properties in accordance with the law okay they can administer also but again here also same exceptions will apply that public morality and then public order and health okay health वगैरह को लेके there can be reasonable restrictions and then article 27 ठीक है तो what article 27 says basically article 27 talks about tax paying of tax na? That it says that no person shall be compelled to pay any tax for the promotion of or maintenance of any particular religion or denomination okay state should not spend public money of any particular religions so here one catch is that uh, you this religious denomination cannot take tax cannot compel anyone to pay tax but they can levy fee okay fee can be levied suppose you are entering a temple they can charge your fee ki itna fee lega 10 rupiah 100 rupiah okay whatever they want to charge so they can charge that fee that much fee they can charge so uh, fee and tax is something different. They cannot tax, religious denominations cannot tax, but you can be, they can levy fee. Okay, they can levy fee on you. So this is one thing. And then Article 28. Okay, so I hope it is clear. No? Article 28 is freedom from attending religious instructions. Okay, so recently this some case was there in relevant to in relation to split verdict wala case. में एक जज ने given some Emmanuel case. Okay, we will be discussing that case some other day. So uh, that is related to this one ना, the religious institutions वाला. ठीक है, तो आपको ऐसा नहीं है कि there are different types of educational institutions. Okay, and then there are like so in some institutions your religious instructions are completely prohibited, and in some institution it is permitted, and in some institution it is permitted on the voluntary basis, on the basis of the consent. Okay, so वो चीज को हम लोग को देखना है, तो how we should make it. So it is like this. So basically it is like types of institutions, no? Types of institutions. Okay, so let me make it below. Yeah, so types of institutions. Types of institutions. So we have to know it because questions are asked from here. No? So types of institutions, and then religious instructions. Religious instructions. Okay. So this is instructions. Huh? Right. So permitted or not. No. So one is your institutions. Institutions wholly maintained by state. Okay. By the state. So here religious institution is completely, sorry, religious instruction is completely prohibited. Okay, with that matlab means the institution which is wholly maintained by the state. Okay, state institute, their religious instructions is completely prohibited. Instructions are completely prohibited. Okay, and then secondly, institutions administered by the state. Okay, by the state, but under but established under any endowment or trust, but established under any endowments or trust. So these are the types of institutions. So here it is permitted. See, though these institutions are administered by the state, but they are basically established under a particular trust or an endowment. Now, having particular belief, faith, or something like that. So it is permitted basically here. Okay, in this kind of institutions, it is permitted. And then there are third kind of institutions. Third kind of institutions is your institutions recognized by state. Okay, so here it's voluntary basis. Voluntary basis. If you give your consent, then you can basically you can basically you are the institutions are permitted. Okay, religious instructions are permitted if you are willing to follow those instructions. Okay, so it is on the basis of your consent. Okay, in this kind of institution. And then institutions receiving aid from the state. So institutions basically receiving aid from the state. Here also it's voluntary basis. Okay, so if you're not willing to listen to the religious instructions, you may not listen. If you're willing, you can listen to the religious instructions. Okay, so these are the things. Okay, so yeah, and then now we will go to, I hope it is clear. So see, whenever we talk about this right to freedom of religion, so there are many issues keep popping up in the news. Okay, so if you see Sabrimala temple ka issues, and then recently hijab wala issues. Okay, and then 1984 ka Jagdish Varandan case wala issues. Okay, so these things keep on coming in the news. So you have to be very vigilant. Vigilant in the sense you have to be careful if you see any such kind of news. Suppose issue of your this conversion. Okay, anti-conversion bill was there. One anti-conversion bill was enacted in Uttarakhand. I'll tell a little bit about it. Okay, so uh, anti-conversion anti-conversion bill. Okay, bill was enacted basically in Uttarakhand, Jharkhand, MP, Odisha, like that. No? So this was there, but in our constitution, actually, our constitution prohibits forceful your conversion. No? But the problem is in our constitution is that though our constitution endorses the freedom of religion, no, for its citizen, okay? But however, the term religion is nowhere defined in the constitution. Okay? Religion is nowhere defined in the constitution, and then by through judicial pronouncement, it has been given expansive content. Okay, judicial pronouncement bana diya, and then there are different essential practice doctrines. These kind of things have been added, na? And then this kind of anti-conversion जो बिल लेके आया था उत्तराखंड झारखंड में, उन लोग ने क्यों लाया था? Because they thought कि many Hindus are getting converted into Muslims. Okay, Muslim and I love jihad wala issues like that. Na? So those kind of things were there prevalent. So they wanted to basically prevent conversion. No, conversion and brought about by coercion and inducement. ठीक है, मतलब जो कोर्स करके एंड देन इंड्यूस करके जैसे कि कुछ बेनिफिट मिलेगा ऐसा करके some people get used to get convert. Basically अभी जैसे कि your Hindu gets converted to Buddhism ना, there has this has been going. Okay, या मुस्लिम में चला जाता है, they think कि बुद्धिज्म में चला जाने से कास्ट सिस्टम वगैरह नहीं होगा ना, and then there are other benefits also. Christians, for example, Christians they give benefits to our tribal people. तो ऐसा करके so this kind of things were behind the enactment of anti-conversion law. But what happened whenever such conversion such laws are passed? Okay, because these things doesn't have particular your connotation in the sense definitions तो proper वाला नहीं है ना, and then uh, it is said that it infringes the right to freedom of religion. Okay, the right to freedom of जैसे कि anti-conversion bill. So if you want to become a Buddhist, no, that is your choice. Okay, so that is your choice, and then you should have that choice. Why there's a need to uh, have this kind of law which refrains you from changing your religion when the constitution is providing the right? No, that is one thing. Okay, so this is anti-conversion bill, and then you might be knowing about Sabrimala. No, Sabrimala case तो आप लोगों को सबको पता होगा that uh, Sabrimala temple, which is age old, मतलब, it's a very old temple, and then there is the age old practice of barring women in their reproductive phase. ना, जो women basically what I'm talking is Sabrimala. Okay, and थोड़ा सा issues भी बता देगा. तो Sabrimala, what happens here of reproductive age, ठीक है, women of reproductive age are barred, ना, are barred from entering the temple, entering the temple. तो basically क्या है कि जो menstruating वाला phase में जो whoever is there women ना, basically they are barred from entering this temple. तो इसमें नहीं घुस सकता. Okay, so basically why on what ground they are barred? On the ground that the presiding deity was a complete celibate. तो presiding deity कहेगी celibate है करके they bar it. Okay, तो एक इसका केस चला था इंडियन, आपका बेसिकली इंडियन यंग लॉयर्स एसोसिएशन वर्सेस स्टेट ऑफ केरला एंड अदर्स ना. तो 5 जज बेंच ने आपका केस उसको क्या बोलते हैं जजमेंट को डिलीवर किया था 4:1 रूलिंग. ठीक है, तो बेसिकली इस जजमेंट में क्या बोला था कि दे सेट असाइड द रेस्ट्रिक्शंस ऑन एंट्री ऑफ वीमेन ऑफ रिप्रोडक्टिव एज. ठीक है, तो सेट असाइड किया था ना. So they said it is a kind of untouchability. Okay, Sabrimala में जो restriction है, it is a kind of untouchability that should not be practiced. Okay, then Sabrimala, but Article 17 में को violate करता है बोल के, ठीक है, ऐसा करके Supreme Court said. But Sabrimala Temple Board said argued that these were the matter of faith. जो आपका जो ये restrictions है, these were the matter of faith. ठीक है, belief, and then it cannot be termed regressive or anti-woman. ठीक है, and then it has urged the court to not interfere in religious practices ना. तो ऐसा करके there has been issues and then इंदु मल्होत्रा, एक इंदु मल्होत्रा करके उसमें ये था, क्या बोलते हैं, जो 4:1 का जो जजमेंट हुआ, तो ये 1 वाला इंदु मल्होत्रा का जजमेंट था, डिसेंटिंग वॉइस दिया था इसने। तो इसने कहा था कि कोर्ट शुड नॉट sit on the judgment over harmless religious belief unless they are were pernicious practice such as sati ना। तो इसने ऐसा बोला था कि इंदु मल्होत्रा ने बोला है कि कोर्ट को रिलीजियस मैटर्स में घुसना नहीं चाहिए अनलेस इट इज हार्मफुल प्रैक्टिसेस सच एज सती ना, तो सती जैसा नहीं होने से नहीं घुसना चाहिए। ठीक है, तो बेसिकली इसमें आपका ये कॉन्स्टिट्यूशनल मोरालिटी एंड देन आपका जो लीगल मोरालिटी, ये चीज का डिबेट इसमें आ जाता है। ठीक है, देयर हैव बीन सीरीज ऑफ इम्प्लीकेशंस ऑफ दिस आपका जजमेंट एंड देन कॉन्स्टिट्यूशनल मोरालिटी का ऊपर भी इसको लेके यूपीएससी में भी क्वेश्चन आ चुका है ना। तो बहुत सारे जैसे डॉक्ट्रिन ऑफ एसेंशियलिटी जो दिया है ना, जो सिरुर मत केस में दिया था, वी विल डिस्कस इट समटाइम। तो वो सब चीज का भी डिबेट आ गया। तो बेसिकली दिस इशू इज इम्पोर्टेंट व्हाई फ्रॉम द एंगल ऑफ वुमेन एम्पावरमेंट। ठीक है, and then women empowerment is important, and then constitutional morality or legal morality is important है, and whether it is a judicial breach overreach, okay, there is also an issue, and then and the debate between group right versus individual rights, that is also one issue. These are the things, okay. So in Sabrimala issues, तो ऐसा करके there are different kind of issues, it will keep coming, तो आते रहता है ना। तो ये, and then when we talk about this we article 20 article 29, okay. तो आर्टिकल 29 का हम लोग जब बात करते हैं, तो दिस आर बेसिकली योर कल्चरल एंड एजुकेशनल राइट्स ना, कल्चरल एंड एजुकेशनल राइट्स ऑफ माइनॉरिटीज, ओके। तो आर्टिकल 29 बेसिकली ज्यादा लंबा वीडियो नहीं बनाएगा। तो आर्टिकल 29 बेसिकली 29 and 30 टॉक्स अबाउट कल्चरल एंड एजुकेशनल राइट्स ऑफ माइनॉरिटी ना। तो बेसिकली ये क्या का बात करते हैं, प्रोटेक्शन ऑफ इंटरेस्ट ऑफ द माइनॉरिटी एंड द right of minorities to establish the and administer educational institutions, okay. So basically what article 29 says, तो थोड़ा सा इसमें you have got this notes, तो notes में already है। ठीक है, तो 29 clause 1 में क्या बोलते हैं, recognizes the right of an individual to preserve, बेसिकली एक इंडिविजुअल का क्या क्या राइट को प्रिजर्व कर सकते हैं बोल के बोलते हैं, यहाँ भी दिया हुआ है। ठीक है, योर कल्चर लैंग्वेज एंड स्क्रिप्ट, तो ये हम लोग का क्या बेसिकली, these are our fundamental rights, okay. Article 29 clause 1 basically recognizes the right of an individual to preserve culture script language ना, distinct language of its own, तो and then it can conserve also। ठीक है, and then article 29 clause 2, okay. तो clause 2 says that state should not discriminate while granting access to your educational institutions, okay. तो means no citizen shall be denied admission into any educational institution maintained by state or receiving aid out of the state on grounds only of religion, race, caste and language, okay. तो this article 29 clause 2 says, okay, tells this kind of thing to the state, okay, that the state should not discriminate, or it prohibits the state from making any kind of discrimination while granting the educational institutions. So these are the things in article 29. So basically these rights are applicable, the article 20, the rights in article 29 are applicable only to citizens of India, applicable only to the citizen of India. And then one thing we should note that कुछ एक चीज को नोट करना है, आर्टिकल जो आर्टिकल 29 है ना, it has included language, ठीक है, language as the ground of discrimination ना। तो एक language को as a ground of discrimination, language इधर में देखिए language, okay, language as a ground of discrimination, it has added, okay, the language has been included as a ground of discrimination. And then what more article 29 says, it grants basically protection to both, article 29 protection to both, okay, religious and then linguistic minorities. Okay, it grants basically protection to both religious and linguistic minorities. No, and then the scope of this article. Sorry, the scope of Article 29. The scope of Article 29. Okay, so what is the scope of Article 29? Scope of Article 29 includes the majority. Okay, all sections. It includes all section, that is majority as well. ठीक है, ये majority को भी include करता है this article. Scope of this article is available to all section including the majority, uh, whereas Article 30 will include only the minorities. Okay, religious and linguistic minorities. We'll see it. So basically what Article 30 says. Article 30 क्या बोलता है? Article 30 basically says all minorities shall have the right to establish and administer educational institution of their choice. Okay, these are right only to minorities. Okay, these are rights only to minorities. Compensation amount fixed by the state for compulsory acquisition of property of minority educational institution. Article 44. The term minority is not defined in the constitution. So this has to be remembered that Article 30 क्या क्या बोलता है basically establish and administer का बात करता है, administered educational institution of their choice, and then it talks about right to compensation if property is acquired by the state, and then it talks about not state it talks about it prohibits the state from discriminating while providing aid to minority institutions. So what is it? Okay, that is important. इसके बाद आर्टिकल 31 जो था, okay, it talks about abolition of right to property, and then it has by 44th Amendment Act, which has been now added in Article 300A. ठीक है, तो ये legal right. ठीक है, now Article 31 is a legal right ना, तो ये, so we have to now see Article 32, okay, which is one of the most important article of the Constitution. This is called as heart of the Constitution, heart and soul of the Constitution. Article 32 is called as heart and soul of the Constitution by B.R. Ambedkar or Ambedkar. Na? B.R. Ambedkar calls Article 22 is heart and soul of the Constitution. Supreme Court tells that Article 32 is a basic feature of the Constitution. What is basic feature? Basic features are those features which cannot be taken away even by amendment. Okay, constitutional amendments. This is what Article 32 is. The basic feature of the Constitution. So basically, what Article 32 does is, let me give you in detail, so you will get all the details here. So it provides an individual remedies if the fundamental rights are violated. No? It provides remedies. Okay. So yeah, so it contains following provisions, some of the provisions. Okay. So what provisions? One, to move to Supreme Court. Okay, for enforcement of FR. Okay, for enforcement of FR, and then the SC shall have the power to issue directions or orders or writs for enforcement of the FRs. No? So when an individual will move, suppose your rights are infringed or violated, so you'll move to the Supreme Court, and Supreme Court will have different Supreme Court will issue different kind of your writs. Okay, different kind of writs they will issue. So we'll discuss those writs. Okay, so writs, these writs. So there, so it's the power of writ. Okay, the power of issuing writs is original for Supreme Court. Okay, but not exclusive. Okay, the Supreme Court has original powers under Article 32, but does not have exclusive power. Exclusive in the sense original. Why original? The writ issuing power of Supreme Court is original. Why? Because only Supreme Court can an aggregate citizen. No? So citizen, affected citizen can directly go to the Supreme Court. So that's why it is original. And then, but not exclusive. Why? Because under Article 226 का अंदर में High Court also have the same power. So let us first discuss little bit. Okay. तो क्या है? What I was saying कि आर्टिकल 32 का अंदर क्या प्रोविजन है? बेसिकली यू हैव द राइट टू मूव द सुप्रीम कोर्ट डायरेक्टली, ओके, फॉर enforcement of your right, and then Supreme Court will issue, has the power to issue certain writs, okay, directions. So basically, Parliament has the power to Parliament has the power to empower any other court to issue directions, okay. So issue directions, order or writs. तो पार्लियामेंट का पावर है कि writs इशू करने का किसको देगा ना. तो that is one thing. And then this the right under this article 32 to move to the court, okay, shall not be suspended, okay, except as otherwise provided by the constitution, except otherwise provided by the constitution. So yeah, this right shall not be suspended, okay. So yeah, basically uh, this article makes Supreme Court the guardian of our fundamental rights, okay, protector of our fundamental rights. तो कौन कौन सा रीट्स है? बहुत सारा रीट्स है, okay. There are many रीट्स. One is here habeas corpus, basically this 5 reads: mandamus, prohibition, quo warranto, certiorari, okay. So these are the most important reads: habeas corpus, mandamus, prohibition, certiorari, and quo warranto, okay. So this is difficult to pronounce. So basically habeas corpus क्या होता है? Corpus means body ना, to have the body, okay. So habeas corpus means basically Supreme Court and High Court can cause any person who has been detained or imprisoned to be physically brought before the court. बेसिकली हेबियस कॉर्पस क्या बोलता है कि हेबियस कॉर्पस प्रोवाइड्स राइट टू द पर्सन ना, जिसको डिटेन करके रखा है कि मजिस्ट्रेट के सामने में 24 आवर्स के अंदर में लेके आओ, एग्जामाइन करने दो, एंड देन इफ इट इज फाउंड दैट ही और शी इज नॉट गिल्टी, देन ही शुड बी रिलीज्ड, ओके. तो ये तो बेसिकली हेबियस कॉर्पस कैन बी इश्यूड फॉर अगेंस्ट बोथ पब्लिक ऑथोरिटीज एज वेल एज प्राइवेट इंडिविजुअल्स, ओके. प्राइवेट इंडिविजुअल्स ऑल्सो कैन नॉट डिटेन एनी पर्सन. आप भी किसी को डिटेन करके बंद करके घर में नहीं रख सकते. दैट इज वन थिंग. The habeas corpus means to have a body. Na? And this mandamus. Mandamus literally means we command. Okay. It basically means we command. So basically the Supreme Court and then जो Supreme Court होता है, ठीक है, या हाई कोर्ट होता है, ठीक है. तो किसी आदमी को when they talk say कि why are you not performing these duties, perform these specific duties, okay. So when they command a public authority or lower court or a corporation to perform certain duty, that is mandamus, okay. Basically we command. Mandamus means we command, no. So this is the thing. And then one thing is that it can be against issued against your public body, corporation, and then inferior court, tribunals, government authorities, etc. No? But it cannot be your issued against private body, president, chief justice of India, okay, governor, and then to enforce contractual obligations. It cannot be enforced, okay. So yeah, and then there is prohibitions. It means to forbid, okay. So basically it means to forbid. No, so basically it is issued by a higher court to a lower court or a tribunal, no? To prevent them from exceeding their jurisdiction. तो कोई ने अपना पावर से ज्यादा jurisdiction कर रहा है, ठीक है, jurisdiction से ज्यादा वो कर रहा है, एक्ट कर रहा है, then they can this higher court will issue कि आपका ये jurisdiction में नहीं आता है, okay, don't take up this issue, ऐसा करके बोलेगा, ठीक है. तो it is issued only against judicial और quasi judicial authorities, okay. तो that is one thing. quasi judicial authorities को करता है. इसके बाद certiorari ना, to be certified or to be informed, okay. To be certified or to be informed. तो ये क्या है? It is also issued by a higher court to a lower court or a tribunal ना. तो ये क्या बोलेगा कि हमको ट्रांसफर कर दो ये केस को, बिकॉज यू आर नॉट एबल टू प्रॉपर्ली डील विद द केस, ठीक है. तो ट्रांसफर दिस केस टू के पेंडिंग केस टू मी, ऐसा करके टू अस, ऐसा करके हायर कोर्ट कैन टेल द लोअर कोर्ट, ओके. तो ये तो इट इज not available against legislative bodies and private individuals, okay. So this is not available against private bodies and individuals. So this is one thing. And then quo warranto. So by what authority? So basically this questions the legality of a claim of a person to a public office, okay. तो किसी भी public office में कोई अगर illegally बैठ रहा है, तो quo warranto can be issued and ask by what authority you are holding this post, okay. तो ये चीज है. तो basically article 32 is very important. It is basic feature of the constitution. It is heart and soul of the constitution. So this is original this is original. Supreme Court has original power within original jurisdiction in this article in regard to article 32. तो original jurisdiction जो आपका 131 आर्टिकल में ओरिजिनल जुरिस्डिक्शन है उसको नहीं बोल रहे. ओरिजिनल इन द सेंस दैट एन एग्रेवेटेड पर्सन, ठीक है, या इफेक्टेड पर्सन जिसका फंडामेंटल राइट वायलेट हुए, ही और शी कैन डायरेक्टली गो टू द सुप्रीम कोर्ट. ओके, सो बाकी समय क्या होता है, सुप्रीम कोर्ट कैसे जाना पड़ता है, बाकी समय हाई कोर्ट में फंस जाओ, हाई कोर्ट का ऑर्डर का अपील करो, देन सुप्रीम कोर्ट में जाओ. लेकिन फंडामेंटल राइट वायलेट होने से डायरेक्ट सुप्रीम कोर्ट जा सकते, दैट इज ओरिजिनल. ओके, बट एक्सक्लूसिव पावर नहीं है. व्हाई? बिकॉज Supreme Court, High Court also have this power under Article 226. So that you should remember ना. तो ये तो इसका बाद क्या है कि we have to see the difference between Supreme Court and High Court power of issuing this writ jurisdiction. Okay, तो basically जब हम लोग देखते हैं कि when we talk about enforcement of fundamental rights by writ jurisdiction, तो both Supreme Court and High Court issues right to reach for protection of or enforcement of fundamental rights ना. तो ये तो बेसिकली सुप्रीम कोर्ट का को नैरो रीच jurisdiction बोलते हैं, and it is said that high court has wider reach jurisdiction. Why it is said? क्योंकि बेसिकली क्या है कि आपका जो रीच jurisdiction है, तो सुप्रीम कोर्ट क्या है कि सुप्रीम कोर्ट कैन अंडर आर्टिकल 32 ओनली इशू रिगार्ड्स टू फंडामेंटल राइट्स. जब फंडामेंटल राइट्स वायलेट होगा तभी सिर्फ सुप्रीम कोर्ट रीच जुरिस्डिक्शन वो कर सकते हैं. तो सुप्रीम कोर्ट का क्या है कि बेसिकली फंडामेंटल राइट्स के लिए ही कर सकते हैं. ओके, तो आपका इसके बाद हाई कोर्ट का क्या है कि दे कैन इशू रीच फॉर अदर पर्पस आल्सो. ठीक है, तो ये है. एंड देन आपका क्या है कि जो सुप्रीम कोर्ट है, दे कैन नॉट, सुप्रीम कोर्ट कैन नॉट रिफ्यूज. ओके, फॉर सुप्रीम कोर्ट इट इज मैंडेटरी टू बेसिकली मैंडेटरी टू एक्सेप्ट. अगर कुछ केस आता है दे कैन नॉट रिफ्यूज टू एक्सरसाइज दिस राइट्स. ओके, बट हाई कोर्ट, फॉर हाई कोर्ट इट इज आपका डिस्क्रिशनरी इन नेचर, डिस्क्रिशनरी है ना, तो वो है. एंड देन बट हाउएवर सुप्रीम कोर्ट का जो जुरिस्डिक्शन है इट इज थ्रू आउट द टेरिटरी ऑफ इंडिया ना. इतना टेरिटोरियल जुरिस्डिक्शन इसलिए सुप्रीम कोर्ट का ब्रॉड है क्योंकि सुप्रीम कोर्ट का क्या है कि जुरिस्डिक्शन ज्यादा है, टेरिटोरियल जुरिस्डिक्शन, क्योंकि थ्रू आउट इंडिया में सुप्रीम कोर्ट का रूल चलता है. बट हाई कोर्ट का क्या होगा, पर्टिकुलर टेरिटरी के अंदर नहीं चलेगा ना, तो पर्टिकुलर स्टेट के अंदर में चलेगा. ओके, दैट्स व्हाई टेरिटोरियल जुरिस्डिक्शन जो है नैरो है बोलते हैं हाई कोर्ट का. ओके, तो ये दिस आर द थिंग्स. इसका क्या बोलते हैं सुप्रीम कोर्ट एंड हाई कोर्ट का बीच का जो डिफरेंस है ना, तो उसका तो बेसिकली हम लोग क्या लेगा, इसके बाद हम लोग इसमें जुरिस्डिक्शन का बारे देगा, सुप्रीम कोर्ट एंड हाई कोर्ट का डिफरेंस देख ले. बेसिकली सुप्रीम कोर्ट का jurisdiction क्या है, बेसिकली थोड़ा सा नैरो है. बाई because Supreme Court can issue writs only with regards to fundamental rights. High Court has wider writ jurisdiction because they can issue on other subjects also. And then Supreme Court का जो territorial jurisdiction is wider because it can issue writs against anybody throughout the country, na? But High Courts only within the specific state. Okay, and then under Article 32, fundamental rights. Okay, under Article 32, this reads that these constitutional remedies are themselves a fundamental right, itself a fundamental right. So Supreme Court cannot refuse to exercise its jurisdiction. However, Article 226 is discretionary in nature for high courts. Okay, hence they may refuse also. So yeah, तो उसके बाद we have seen different types of writs: habeas corpus, mandamus, prohibition, certiorari, quo warranto. तो habeas corpus क्या बोलता है, literally means to have the body. Okay, to have the body, तो body को actually you have to present it before the magistrate within 24 hours. Okay, तो 24 hours में present करना है. If not found guilty, if the guilt is not proved, then he will be released. Okay, प्राइवेट और पब्लिक दोनों का. मैंडामस भी कमांड, तो बेसिकली स्पेसिफिक पब्लिक ड्यूटीज वगैरह को करने के लिए कमांड करते हैं. प्रोहिबिशन टू फॉरबिड, ठीक है, तो अपना जुरिस्डिक्शन से ज्यादा मत करो बोल के, यूसर्प मत करो करके प्रोहिबिट करता है. सर्टियोरेडी, टू बी सर्टिफाइड और टू बी इन्फॉर्म्ड. ओके, तो बेसिकली हायर कोर्ट विल टेल कि गिव दिस केस टू अस, सेंड दिस केस टू अस. ओके, अपना प्रोसीडिंग रोक दो एंड देन सेंड इट टू अस. ओके, तो ऐसा करके बोले. क्यू वारंट में by what authority ना, by what authority, कौन सा authority से you are holding this post, ठीक है, legality of the post को देखता है कि क्या है करके ना, कैसे होल्ड कर रहे हो क्या. So this is the class for today. Okay, so आज का क्लास है. So we will be doing classes. I think we will be doing in morning. तो मॉर्निंग में क्लास करेगा अभी से सुबह को. मतलब और जैसे जैसे दिन बढ़ते जाएगा, लिटरेचर फेस्टिवल सामने आते जाएगा, तो things might get more hectic. Okay, so we'll work it out accordingly, but we'll make sure that the class are not disrupted और क्लास चलते रहे. हाँ, तो any question होने से ग्रुप में डाल दीजिए. I'll share the link.